I'm going to show you, you're going to watch me go through an essay just like the grader. Now realize I know this essay inside and out. Um, I usually don't grade essays until they release the selected answers. So this is actually not the smartest practice, but I feel good enough about this essay that I can actually legitimately grade it to to standards that I'm accustomed to. All right, so let me share my screen here, and you guys are going to watch as I go through it. If I don't say every word out loud, that's because my mind is thinking fast. I'm reading faster than I'm speaking. So, okay, and Maddie, this is yours. Okay, federal court said about diversity. Okay, plaintiffs complete diversity. Some states defended 5,000 in case you guys 100,000. You got that. What about O? It's 50,000. It's clear appears that O's damage less than cannot. They can be aggregated. No, they cannot be aggregated. So that's wrong. Diversity is met. Okay, so you totally missed diversity. So, oh, wait, let's see here. Supplemental. So only plaintiffs can aggregate their own claims, not a defendant's claim. Scott Court may someone raise, okay, transaction occurrence. Yeah, just related. Accident use. Oh, now O wants to bring a claim for damage, like the court to file a claim, even if diversity is not met. How? Because it relates. Yeah, but you're not explaining the rule. Not met. Okay, fine, but yeah. Based on the foregoing, the federal court of subject matter. Yeah, you got to the right answer but the wrong way, and you said aggregation, but then you talk about supplemental, so I could tell you're a little confused. Personal jurisdiction, yeah, there's no traditional basis, there's no domicile, the legends to serve. Okay, traditional basis not met, of course. Modern star like starches, okay. California does have it, you're right. No facts. Well, California does have it. It doesn't matter in federal court. Well, it doesn't matter. Not give writing, okay, constitutionality to be determined, yeah, minimum context. Reasonable is fair play. Got it, must be foreseeable. In trying is presumed they'd be driving in and out of state. Well, the accident happened in state. That's all you need to go. Like, he actually caused the accident in California. It was foreseeable. Yeah, driving, exactly. He took it, yeah, purposely avail himself of the laws. And okay, so roughly you did okay there. Foreseeable, related, it's specific. Here's the economy was not specifically to the issue in the claim. What do you mean? It's exactly the same. There was there was transportation. He failed to stop, caused the accident. One may argue there's nothing arguable here. This is a specific jurisdiction, and I mean it's a classic example of that. General jurisdiction, no one's at home anymore because the Supreme Court has pretty much eviscerated it, state to state, neighboring states. Like no, it's not no. So it's not continuous and systematic. He's not at home there. Fair play, Burger King factors, and you spend a lot of time here. You must have memorized those because these really aren't an issue. The only time the Burger King factors come into play is generally when you're overseas. Made up place burden in neighboring continuous states. Okay, we talk about systematic continuous, so you just don't really fully understand that. It makes sense. Place of domicile, I don't know what that's about. California. The interest having a claim, lifelong residence. Okay. Well, yeah, fair play and substantial justice is met, but you do a decent job. I mean, not the greatest job. Okay. Also, with let's see, we do a service of process. 90 days. Oh, look at that. Rule 4, M as in Mary. Nice. Good cause is shown. Summons, okay, without 18 years old. Personal to witness dwelling with a suitable person. Nice. But who resides there? It is served to the defendant's agent. Nice. Or you could also follow state law. The max date when the service is made. I don't think that. Because they're not getting at that. Resume was 90 days. Okay, fine. P's lawyer. A lawyer's older than 18. Yeah, they'd have to be. Actually, I think there was like a 15-year-old lawyer recently. Served a corporation. Well, they don't say anything about. They're not asking about. They're asking about Dan properly served, not about NBL. So answer the call to the question. Not included as a corporation. Who cares about the corporation? Did not personally serve. D was not left to a suitable person. They slid on the door. It's also improper. L did not serve the complaint to D's agent. Okay, so you missed two things here about service process. Number one is that he can. He's already answered the complaint, so he's waived it. And number two, a lawyer is not a party, so the lawyer can do it. Oh, there you go. I think he did it right here. Time, okay, motion proper service. Court may allow reservice. I think you missed that. Okay, now here's scope of discovery. All I care about is the 10 years. There you go, 10 years. There's no privilege over broad to claim, okay, or the plans to reduce their federal courts. Broad, okay, necessary as explained. You don't need to put the all caps, by the way. I don't think it's a very good practice. 10 years are not likely to promote, I know you meant proportional. I get what you're saying. Okay, motion to compel, good faith, got it, able to show resolve the issues informally, but they know, I think they did actually mean confer, didn't they? All right, so it seems like okay, 12. All right, so my guess is you probably went a little bit over time on this. You spent time on like the Burger King factors, kind of a lot of time, which wasn't really an issue. You also went into call. So here's the thing. It seemed like you rushed to get to finish it, which is a grave thing to do. You want to take your time in the first 45 minutes and then wrap it up in the last 15. All right. A lot of people rush to finish. And here's the thing you don't realize. They front load all the essays. What do I mean by that? When there's 4 calls to the question like that, almost every time, not every time, but almost every time, the most important calls will be 1 and 2. And they know the examiners are actually really, really, really fair. It's weird to think, but they are. They're not going to force the most important issues at the end because they know you're running out of time. Generally, calls 3 and 4 are going to be very light. So for call number 4, I could see like you either had extra time or you just felt like you knew it and you spent all this time on call 4, which, okay, but you kind of missed some things at the beginning. So here, let me think about your score. Don't tell me what it is yet because I haven't, okay. I'm not going to pass this because of the supplemental jurisdiction. You didn't catch specific. Larry is a lawyer. He's not a party. You did talk about 12B, which is fine, which gives you the whole, I'm really torn on this because they did calibrate this essay higher than the others, which is why I don't want you guys to focus on scores because you don't understand it. I'm between a 55 and a 60. Personally, I'm kind of, I could go either way. I could really go between 55 and 60. I'd be surprised if it got a 65. You know what? So my question is it closer to 65 or 50? Probably, so I'd have to give you, because I think it's closer maybe to I'm going to go with 6. I can go both ways. 60, what'd they give you?
60.
Okay, there you go. And again, the subjectivity, they get a 55 or even like 65, whatever. But I think 60 is probably the fair score. Now, question for you. I did take a little bit longer on that than normal, probably because it was 1,800 words and the average is like 12 to 1,500 words. I'm going to ask this to where is that? Neuron. Does it matter how many words are typed?
No.
Not at all. Exactly. No. What if I showed you a selected answer that was 1 page? Perfect answer in 1 page. You want to see it, Daniel? Okay. I don't lie.
Yes, because I'm not very fluent in talking English, so that was a question for me.
Mm-hmm. It doesn't matter how much you type. All right, so let me do this. Okay. So let me share my screen. All right. So this is a contracts essay 2001, February, question 6. Here's page 1, and here's the back of page 1. That's it. That's it. Come on, I see one. So answer B. And the funniest thing is, you know what the funniest thing is? This entire first paragraph was never relevant. They didn't even do it. But that's it. 2 pages front and back. That's it. That's it. How about that? So 1 page, 1 full page front and back. And you know what? They did it so brilliantly. Now, when we get to contracts, I'm going to refer to that. You're going to get to see it. But they did it so brilliantly. They just answered it, and they answered it perfectly. I mean, perfectly. And I thought the funniest thing about it was that first sentence about the formation was completely irrelevant. Like, they didn't need to put that. And the examiner gave them a perfect score. That was from 2001. Now, it doesn't matter how much you type. It's the accuracy. It's like making sure you get it right. Okay, you want me to do it? What do you guys think of the grading process? Somebody raise their hand and tell me what you thought and how it differed from what you might have thought it would be. Because first of all, let me ask you guys this. Let me ask somebody a question here. Catherine, let me get you here. Do you think I gave it its due attention? Do you think I caught everything?
Yeah.
No. Yeah. I mean, I think I gave it an incredibly fair read. I saw what she was thinking. I mean, she typed what probability. I knew she meant in proportion. I saw that she went to the Burger King factors. I noticed that she talked about aggregation when it was really supplemental, and then she brought it up, and she also brought up 12B5. She forgot to mention the lawyer. I don't think there's any detail I missed. I got the score right, but I think that's semi-relevant. But I think the more important thing is I was able to read it and see it. Here's why the grader can go so fast. Do you know how many graders you have? Do you know you have 6? Do you know you have 6 graders? Lilith?
I have a different question, sorry.
Okay. So you have 6 different graders. So when people, did anyone read the myths about the bar exam that I sent you? Did you guys have a chance to read that yet? Let me pull that up. Okay. Let's go to the myths about the bar. It was in today's materials, but again, there's so many things. Okay, go to page 13 of 15. Go ahead and click on that. So on page 13, I failed because my grader is having a bad day. It would take 6 or even 12 different graders to have a bad day and make this statement true. In California, every one of your essays are read and graded. In fact, at least 6 different people will look and grade at the written portion of the exam. The cover of each essay, well, this is when they used to actually do that. The color of your essay is coded differently and sent to a different grading room. A committee member leads that group's calibration session. Each group is responsible for grading only one essay or the performance test. Since there are 5 essays and 1 performance test, there are 6 different graders scoring your exam. Thus, if you are a bar grader, you'll only grade 1 essay per bar exam. Do your best and the rest will take care of itself. So for those of you that like this person was a former bar grader, you know what? That doesn't mean anything. That means they know 1 essay. It doesn't mean they know anything about the bar. They might know that 1 essay, and you're never going to see the exact same essay twice. Sure, they might understand that grading a little bit better, but the grading is also on the State Bar's website. They tell you exactly how the grading process goes and the calibration sessions, how much they get paid. I mean, where do you think I come up with the stuff? You think I just pull it out of thin air? Believe it or not, all this is on the State Bar's website. Everything I've told you is on the State Bar's website. There you go. Okay, Lily, you want to ask your question?
Yeah, I wanted to ask you, could you have given it a bit more? Like you read it and you estimated it, but if you were the grader, would you have given
That's
65?
exactly how, no, I would have given it a 60. That's right. I mean, I was between a 50. I would have like, did you not watch me go through it? I said, I'm between a 55 and a 60. And then I have to ask myself, is it closer to a 65 or is it closer to a 50? Well, it's closer to a 65, which means I'm going to err on the side of a 60. That's why I ended up with a 60. Did everyone see how I did that process? Like, go ahead.
I also noticed that when you spotted a mistake in the first page or even the page and a half in the beginning when you were reading your essay, it made you a little bit more critical as you continued reading. And I think that also you did go back to kind of weigh that mistake later on once you were done. And then once you got to the part where I think you disagreed with her analysis for specific jurisdiction,
I didn't disagree with it. It was wrong. I mean,
yeah.
there's a difference. Like, it was wrong. It's a specific. It's a classic textbook example. It's specific. And when she said, like, there's no argument there. So go ahead.
So I do agree with what you wrote about how being really top notch with your first couple of paragraph weighs into like the type of discretion the reader will give as they continue reading. So my question was, I understand you always have to follow the how the questions are presented, like question 1 and question 2. But if there are multiple issues that need to be discussed in the first question, should you be strategic to like mention and discuss the first thing that you are going to be able to write a good analysis about to kind of set that stage and set your best foot forward?
Yeah. We'll get in that definitely more throughout the course when we go in a little deeper in the essays. But here's the thing. And you make a good point, but you think I was being hypercritical, but no, I think I would have been like that even if it was great in the beginning. Because my job is my job is to find out what she's doing wrong and right. So I just happened to notice the things that were just off or that were, not up to the law. But you make a good point. Watch this. Think about everybody you've ever met in your life, every video you've ever watched, every movie you've ever started, every TV show you watched the first couple of episodes, and every book that you've ever read. You're going to form a first impression, right? Like, you ever meet somebody and you're just like, I like this person. And like, there's people that you meet and you start off wrong and you'll never be friends. You'll never like each other. So it's kind of the same. There is a little bit of psychological aspect of that. So you do want to put your best foot forward. But although I understand what you're saying about maybe I was being hypercritical because of the beginning, maybe subconsciously I was, but I don't think I was. Who knows? So let's see how I do in the next couple, and we'll see how that plays out. But thank you. That's great. Amanda?
So my school, which I by no means hold to be an authority regarding stuff about the bar, But they mentioned that when you write your essay, you should write it as though the grader has never even read the fact pattern.
Okay. Yeah, fine. I mean, yeah.
Okay. Okay.
You know, one of the things that I do when the MEE essays come out, that's the national conference writing the answer. And it's funny, Amanda, you know what? I'll do this with essays too. I won't even read the fact pattern. I'll just read the answer. And then I'll read the answer like 2 times and I already know what the fact pattern says based on the answer. I'm like, okay, well, you know, so I actually will do that sometimes. I don't think you guys should do that, but I just like reading the answers because she didn't even tell me in her answer that the guy caused an accident there. Like, it was just kind of, it just wasn't like her thoughts weren't put together well. And think about this, and I'm not beating you up, you know, Maddie, like, by the way, her sister was in my course. I went to her sister's wedding. I love your sister. She just had a kid and she hits me up every Super Bowl, by the way. Your sister is adorable. I love your sister. And you guys might have seen on the, if you ever seen a TikTok video of me, that was her sister in that video that allegedly, you know, that was her sister.
Video?
Yeah, that whole like whatever somebody did, like your sister had no problem. Your sister wasn't even my student then, but she's like, I like this guy, and she signed up. And the rest is history. So it's crazy. Don't believe everything you see. Don't believe everything you read. It's not anywhere near what reality actually is. And I'm telling that with everything in life. Okay. So what are they going to say? What was the point of what I was saying? So yeah, I'm not beating you up about that. But I forgot what my point is. I got distracted. Sorry about that. Okay, want to do the next one? You guys have a suggestion? Want me to do the next one so you guys can see it again? Okay. So thanks, Rita. Okay. Okay, now I got Cheyenne's on the hook. And I might be saying your name wrong. It's Cheyenne G. All right, can everyone see my screen? I can't see you guys. Let me see if I can see you guys. Oh, got your meeting. There we go. Okay, I swear. I've tried so hard, so many times to use Zoom the right way. Can you guys see my screen? Someone yell at yes.
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 Okay, he sent me the wrong essay, so you're done. Okay, oops, sharing screen. Okay, thanks for saying the wrong one. Okay, question 4. I think I might have done that one before. Let me see. Where's that? No way, I'm just looking for it right now. I love the way you guys follow directions. Okay. Justin, I got yours up. Justin Medellin. Okay.
Be gentle.
No, don't say it. You can't make any comments or I won't do it. Yeah, because I excuse the objectivity. Why can't I see you guys here as well? I just want to be able to see you guys when I'm going through it, but I just can't seem to get the 2 things together. All right, now you guys can see my screen. You can see the essay, right?
Yes.
Gosh darn it. It's not letting me see you guys. Somebody wants to teach me how to do Zoom. I'll pay you by the hour. Okay. God. Sorry. All right, where'd it go? It went away. Wait. Okay. I've actually reached out to Zoom.
Do you see our faces on the right side
No,
or
not
the
when
bottom?
not when I share the screen. I just can't
No,
see.
no, when you're not sharing the screen.
Yeah, I see your faces. Yeah, absolutely.
Is it on your right side? Because you can technically take us out to on the side separately while
Yeah.
you're sharing.
You know, maybe after class, will you show me that, please? That'd be really
Yeah.
helpful.
Yeah.
Can you guys see my screen now? Can you see the PDF?
No.
Okay. Oh, Jesus. Now you can, but I can't see you. Okay. There's a federal court of submitted. Okay, I'd like to see the number 1 there just because California submitted rises from a decision can pay for the claim, but you're not talking about Owen. You aggregated these claims, which is wrong. Federal courts limited federal questions. Okay, diversity of jurisdiction, got it. Citizen of Nevada, okay, Thousand Oaks, okay, both resident came out. Controversies, 100,000. Okay, that's for Peggy. Let's see about look at that, he did it. Supplemental for Owen, federal went over here jurisdiction, and Even's claim does not meet the amount card. He's the owner of the Evans officially related to claim. There you go. I like that, sufficiently related. Exercise jurisdiction over it. Yeah, this is the one situation where plaintiffs can use supplemental jurisdiction. Removal. I don't know what you're talking about, removal. Nothing there. I'm just going to skip it. Federal court have traditional personal jurisdiction. There's a traditional basis, domicile, consent, of course. None of that happens, so there's no reason to go there. Long arm statutes, got it. California follows it. That's just fluff. Constitutional basis, one more fluff. So clearly you did a great job memorizing the template, which is fine. Purposely availed itself. California has conducted business. Well, yes, they're jointly and severally liable. They're vicariously liable. Intentionally target. Intentionally target like that. Business there is offered to transfer to bingo players. Conducted state. Well, it's just the accident happened there. It's not like they advertised there and someone for breach of contract. Not by accident. Liable is availing itself. There you go. Making money. Yes, yes, yes. Also, they're taking advantage of the roads. They're taking advantage of the police. They're taking advantage of the hospitals and the protections of it. They're driving on the roads. Those roads aren't free. Specific jurisdiction at home. It's for general. Got it. Minimum contacts. Well, you don't specific jurisdiction is minimum contact directly related. Yeah, because it's only contact is directly related. Okay, fine. Burger King to determine. Okay, established. Okay, state's interest. You got all those. Good. We may like to court. Okay, burden is low. Exactly. Yeah, I like that. Look at that. Good job. That was a great sentence. Transfer. Okay, and mention most of the evidence. Oh, substantial interest. Okay, good. And you're right. You talk about the plaintiff's interest. You talk about the burden. Great job there. Was he properly served? 18, not a party. Got it. Valid jurisdiction. That's true. State law. So substitute service can be made. Nah, okay. L, the area probably served it, but he was an interested party as an attorney. Nah, he's not. They got you there. Because Larry is actually technically not a party, even though he's the attorney for the party. No, I did not have access to the officials. Okay, got that. Oh, you totally missed that one. Oh well. Scope of discovery, non-privilege. Okay, relates 10 years. Got it. You got that. Oh, it's so good. Oh, well, at least the good news is your ceiling, your floor is going to be a 60. Would it get a 70? I can't. You did such a great job everywhere else. You got the supplemental. Boy, I would give it like almost a 70, 75 if you didn't miss the part about, yeah, you kind of missed call number 3 pretty big. Can't give it a 70 or I can't give it a 75, no way. Won't give it a 55. So now I'm between 60 and 70. I'm not feeling good about the 70 because of the way you missed call number 3. So I'm down to 65 and 60. It was a little bit better than the last one, but God, you just left such a hole in it with call number 3. And here's the thing. Even if you think that Larry is a party, don't write yourself. The examiner's directions actually say, don't write yourself out of a problem. Just because he's not a party, just say, but if he was a party, then would service be proper, which is the whole thing you missed, and then you missed the whole. I can't give it a 65. I got to go with 60. What did they give you?
They gave me a 60, Jason.
Okay, got it. All right. So now, Aruj, do you think I was hypercritical? Actually, everything was really good, and then I ripped it apart. Number 3, right?
Yeah, I'm like, this guy's like gonna pass. He's gonna get a 65. I was really rooting for him.
He would have got number 3 right. He would have got a 75.
Yeah,
that's how good it was. I mean, he did really, really good, but you miss you missed FRC rule number 4. And by the way, Maddie, I love the fact that you did 4M, which is the 90-day thing, because they changed that from 120 to 90 days. I'm like, so you must have been aware of that one. I'm like, oh, that's cool. They weren't asking for it, but I kind of like that, like there. It's kind of crazy because she was just on such a low trajectory and he was on such a high trajectory, and then they intersect at the exact same score. So, all right. Should I do one more? You guys want to see one more? Okay. Got it. All right. Now, let me ask you something. I want someone to go ahead. Jasmine, I want to hear you. Or somebody who has been told what the graders do in the 4 minutes and the $4 and they look at headings. Tell me now if you think that's true. Or if you're starting to maybe think, maybe that's not true. Jasmine, what do you think?
Yeah, I don't think that's true.
Anybody could say anything they want. I always ask them to prove it. Like, don't tell me, show me. Which is why I tell you that, like, even when you guys first called me, a bunch of you told me, like, about the course, how are we going to study? I go, I don't want to tell you. Let me show you. Let me give you an assignment. Let me walk through with you. Let me explain concepts. Let's go through an essay together. Because it's better that I show you, because anybody can just talk. Talk is cheap. But proving it to you and showing you example after example with no headings, showing you no rule statements. Granted, it was only one example. Okay, fine. Grading the essays by looking at it. And does anybody here think that I didn't give either essay its due respect? Anybody here go, you actually, you didn't really do any, you did a disservice by not reading it carefully. I thought, and please let me know. Like, let me know if you think that, because I think I caught everything. Not maybe a crumb or two here, but I think I picked up and scooped up everything. And I didn't time myself. I forgot to time myself. But Serena, how long do you think that was that it took me to go through the second essay?
Like you were reviewing, that's what you mean?
Yeah, the one I just graded, Justin's.
Like maybe a minute?
I think probably took a little bit
Pretty
longer.
longer?
What's
It's
that?
pretty fast.
Yeah, it was pretty fast. And that's how, now, only if I'm a grader, I'm only grading that essay. So I'm seeing that essay over and over and over and over again. I know exactly what I'm looking for. I know Larry can serve. I know you couldn't leave it at the house. I know what the, that it's fair for them. I know that there's specific jurisdiction. I know that you supplemental, not aggregation. So there you go. All right, one last one. Let's do one last one. And of course, that doesn't mean I'm not going to go through it with you later, but we will, and the reference guide talks about this, and we'll go through it in a little bit. We will go through your essays. If you took the last bar, not most people here aren't repeaters, but if you are, there's nothing to be embarrassed about. Everyone here has got in the same boat. None of you have passed California. I will go through it when we go through the subject, and it's in the reference guide on when we'll go through the essays and how we'll go through them. Okay. Let's go here. And Helen is up next. Okay. Let's see. Here we go. Subject matter. Okay. Federal questions. Okay. Federal law, negligence. Good. It's not a question under federal law. Good job. I like the fact. I think you're the first person that brought up negligence. It could be mistaken. Diversity, amount of controversy, 45. Complete diversity. Let's see. Okay. Got it. Corporation. Nice. Play lifelong residence. Okay. Defendants, citizen of Nevada. Okay. LBA. Yeah. I love that. We can infer that they're domiciled in Nevada because the facts never said that. I love that. Good job. That's somebody who read carefully. And of course, the other answers might have said that, but I love the fact that I just saw that right there. Amount of controversy, 75, demanding, okay, got it. Owens demanding 50, meets the amount of country. Owens' claim is below and not satisfied. Aggregation, multiple plaintiffs. No, it's one plaintiff can aggregate against multiple defendants, so it's not aggregation. You don't spend too much time like that, which is actually a good thing because it would hurt you. Supplemental, here we go. Claim by themselves, okay, room divert. Good. Okay, you're talking about Exxon, room diversity, exactly. Cannot be supplemented. Did you say related? I'd like to see the word related in there. She satisfies diversity, got it, bringing claim of negligence, failed to stop, okay, Peggy, Iron expresses both the plaintiffs in a common occurrence, same thing. As such, both arise of the same transaction and should be able to come in a supplemental. Yes. Okay, good. I don't know how you guys knew that. I beat my students over the head with Exxon. Okay. Good, did not defeat diversity. Very good job on number one. Actually, perfectly done on number one. Personal jurisdiction, traditional basis. There's no traditional basis. I don't even need to read the facts. You guys know there's no traditional basis. Long-arm statute, big deal. Defendant's conduct essentially at home. Dan is a bus driver. Okay, time of the incident transported. This one incident is not so. There you go. Look, that's good. Do not have to drive in. Presumably not a company. Presumably that company operates in Nevada, or else Dan would be not in California perfectly. Okay, don't imagine being contracted to California. Got it. Specific here. Accident occurred in LA. Done and done. That's it. That is it. Fair play. God, what's up with these Burger King factors, you guys? Recovering moments is damage beyond repair. Okay, travel incurred costs. Flying to another state. Okay. Doesn't have a car. Well, okay. Probably doesn't have a car. Okay, I don't think that's relevant. Okay, didn't have a problem back and forth. Grave inconvenience. Addition. Okay, they talk about the defendant. Got it. Bingo players not be fair to make them all. I don't think the bingo players have nothing to do with this. Quite possible key witnesses. Okay, you're talking about venue though, but fine. I'll give you credit for that. I see what you're doing. Yeah, I know what you mean. Like, yeah, it's like where the witnesses. Okay, I could kind of see that as part of a fairness argument. Cost of burning the defendant. Okay, in California, defendants will argue the witness had no trouble traveling. Okay, I'm gonna pass on that because you did everything okay. I mean, you did a good job. You put a little too much in. Fine. Probably served at a party, okay, California, but they're not asking about California. It's procedural, so we don't worry about California procedural law. We're in federal court. And that's something important to realize. You don't talk about California law here. Although if you're just doing it to like kind of show off, like, hey, I know this, that's fine, but I would just kind of maybe shy away a little bit. Larry's not a party. Good. Look at that. Larry is not a party. It's something that Justin just learned, which is fine. Because you'll see that in the MBE, serve the complaint, personal service. Serve the defendant in a way that's provided proper notice. He did the same with Dan. Personally serve and slid on the door and not receive notice. This is not proper service. Leaving out a door to ensure someone is cognizant Yeah, it had to be someone of suitable age and discretion. So the rule was a little bit rocky, but you got the gist of it fine. I would have liked to see how he waived it. And like, Maddie, she's the one to discuss, she's the only one to discuss in 12B5, how he probably waived it. Here's the motion to tell. There's the 10 years. Claims evidence is discoverable, not privileged, relevant, and propounded. Where's the proportional? I like to see the proportional things. Argue is relevant. Yeah, okay, there you go. That's the same thing as promotional. Okay, great. So all the documents, injuries, a claim, an attorney-client privilege, got it. Wow, 22,000 words. This is a lot. So this was obviously a passing essay. This is very good. This is incredibly well written. So I'm already past the 65. I'm between 70 and 75. 75s are hard to get, but they did calibrate this high, so it would not surprise me with the 75. What did I think there was one thing I did not like. Yeah, no, I don't think there's much I didn't like. Proper service, about just the whole point of with the proper service, like maybe you could have tightened like the one thing about, well, he waived it by answering it. Everything else was just directly on point. Boy, if you got below a 70, that's an injustice. That's an incredible injustice. I don't think they give you an 80. I don't see an 80 here. I'm between 70 and 75, and I'd probably be closer. I'm gonna hope I don't kick myself for doing this. I'm going 70. What do you give you?
It was a 70.
All right, there we go. All right. So, hey, 3 for 3. That's not normal. Like sometimes I'll miss, like usually out of 5, I'll miss 1 by like 5 points. I'll miss like 2 by 5 points. So you guys are seeing, obviously, I agree with that. Should give you a little bit of confidence in the grader. Okay. God, it's so hard to get a 75. It really is. I mean, here's the thing. It might be hard to get a 75, and that was almost as good as it can get. But here's the thing. Where's the flip side of that? It's incredibly hard to, it's almost impossible to get. You have to work hard to get a 50. I mean, you got to really try to not answer it to get a 50. And I'm not blaming anyone who got a 50. Yeah, you just didn't know it. You know it. You be honest with yourself. It's like, I didn't know it. 55, you can really stay away from if you just really know, if you can read the facts carefully and just use common sense and think about it and think through it. Now, you might get the occasional 55 here and there. I get it on an essay that you're just like, shit, this is my worst subject. But if you can just, it's kind of like think about golf. If you can par at 60, if you get like a birdie or an eagle on one of them, you're going to pass the essay portion. So you just want to stay away from the incredibly low grades. That's your bottom line. And how do you do that? You stay calm, you read the fact pattern carefully, you answer the call of the question, and you think before you start writing. Okay. Last things last, we only have